Good afternoon, everyone. Thank you for coming to this session, Electronic Resource Licensing Explained, an A to Z licensing guidebook for libraries. We have a great panels. Sunshine Carter, a librarian for University of Minnesota Libraries. Jane Montavon-Green, head of Electronic Resources, University of Kentucky. And we have Samantha Teremi, licensing librarian from University of California, Berkeley. And we have Erik Limpitlaw, digital collection licensing librarian from Stanford University Libraries. And I will hand off the presentation to you all.
All right, I'll go ahead and start. Hi, I'm Jen Montavon-Green. Like you said, I am the head of electronic resources at the University of Kentucky Libraries, and I was one of the reviewers of this ebook you're going to be hearing a little bit about. So I'm going to start off by talking a little bit about the background of the book and the ways I'm using it as a licensing librarian. I'll also give you a heads up. It's storming outside. My dog is outside the door in the other room, but she is not very happy about it. So I've heard a couple of barks. So if you hear that, that's her. My husband's with her. Just a heads up. Let's start. Sunshine, can you put it the first slide? Next slide. So I think we all know that recurring purchases typically form the bulk of libraries' material budgets. As we've all seen, the licensed electronic resources are now one of the biggest part of those recurring purchases. But at the same time that number is increasing, we're also seeing increasingly restrictive clauses in license agreements for electronic resources that limit what libraries and patrons can do with the resources that they pay for. Licenses often override fair use and other library rights. And we're seeing this right now with the proliferation of AI clauses that are starting to pop up in a lot of these licenses. Next slide. So in light of these threats to fair use and library rights, we're hopeful that this new ebook will help libraries use licensing strategies to preserve those rights. It has a Creative Commons license, attribution, non-commercial, and is available for no cost download in EPUB, digital PDF, and print PDF. There's also if you go to that second link, which we won't do now because switching screens is difficult sometimes on Zoom, but that second link that's direct, there will also be a button that allows you to read the book in your browser in HTML form. And it's really nice because it also provides direct links to different sections of the book. And if you want a physical copy, it's also available on Amazon Print on Demand. ARL wanted to make this as widely accessible as it could for libraries of different sizes, variety of budgets, people who aren't necessarily sponsored by a big library. I've recommended it to one of our library school professors who is going to be using it for his electronic resources course. Each section within the book focuses on a different clause of licensing, including what desired result is, background, desired language section that has sample clauses that can be used in a license, and tricks and traps, which can highlight language that could seem innocuous when it pops up, but could cause problems down the road. Erik and Samantha are going to be talking more about the content later on, but the result is it makes it a really practical book for librarians. Next slide. The book was officially launched in January, and the response has been really heartening. You can see we've had almost 3,000 downloads, more than 16,000 page views, more than 7,000 unique visitors, and almost 40 print-on-demand copies. In my library, we've already used this book in a number of ways and have envisioned some ways we might use it in the future. A few years ago, I trained a library graduate student to review licenses and add the licensing terms from the license into our LMS. I don't know if anyone's had to train other people on how to do licensing, but it's not an easy task. It took a lot of work. We went through a lot of like our own licenses, and if we had had this book to refer to, oh my gosh, it would have been so much easier. Currently, we're actually having to do that process again. Our head of acquisitions, who's my second pair of eyes on licenses, is retiring at the end of December. So we are currently training our collection strategist to replace her in that process. So we've walked through some licenses, but I've also sent him this book to provide background, and he's been like, it's been really, this is really helpful. But it's also not just for beginners. In the review process, I've been doing this for 15 years, and I learned things that I'm now incorporating into my practice. I've also spoken with librarians in the past who the university legal department negotiates all their licenses up front. They're not allowed to do it in the library. And they're like, the legal office doesn't know the nuances of library resources. And even though we do a lot of negotiation ourselves in our library, I have a really good relationship with our contact in the legal department. And so I actually told her about this. She was like, send me the link. Like, I'm sharing this with all of my colleagues so they understand kind of the library background as well. So I can really see this being used at the libraries who don't have that control of e-resource licensing, being able to share this with their legal departments so that they better understand what they should be looking for to protect the library, and also to make sure the library has all the use rights that they should be having. I've also pulled licensing suggestions directly from the desired language and sent that to vendors when requesting changes. So it's a really practical resource. I'm really grateful to the authors for creating it, and was really thrilled to be a reviewer and be in on this from the ground floor. I'll be using it for years to come. I'll be sharing it with a lot of people, and I really think it's a great resource for librarians with all levels of licensing experience. So now I'm going to pass it over to Sunshine.
Thank you. Sorry, I'm managing the Zoom, and so that always adds an element of fun. Following up on what Jen just shared, was wondering if maybe in the chat, if you could think upon and perhaps put into the chat, how did you learn to review licenses? Because it's not something that we're necessarily taught in our education. So if anyone wants, I don't know if chat is open for everyone. It doesn't look like it. But maybe just reflect on how did you learn to review, and also maybe how you train your new librarians that you might be responsible for teaching these skills to. I know for myself, I learned a lot through other librarians at our other campuses who had more experience in this. I learned a lot from my general counsel over the past 20 years and have cribbed data. I've used all the model licenses, I've used the books. And so for myself, this book really kind of seems to have all of the information in one place that you can pull from, learn from, especially the rationale. Oh, I see now, I see chat coming in here. So yep, trial by fire. That's definitely a path I've taken. Predecessors, sessions, just reading a few of the answers in here. And in-house training, that sounds really interesting. So I'll tell you a little bit about how this book was pulled together from the perspective of someone who was a reviewer for this. So in addition to the authors, there were 5 reviewers. Jen and myself were reviewers, along with Faye Christenberry, Dan Mack, and Wendy Ellen Shelburne. And we all have had extensive licensing experience of our own at our respective academic institutions. And so the authors would work on chapters and sections in various rounds. and those chapters and sections would be tracked in a Google Doc. Then the rounds of written sections were released to the reviewers. We went in and we self-assigned chapters and sections, I guess based on our favorite topics, or maybe areas that we were familiar with or were less familiar with. And that Google Sheet was used to track the progress for authors and reviewers. So from my perspective as a reviewer, I found it really helpful for us to have group meetings between the authors and reviewers to help organize the process. I think the tracking spreadsheet came out of our first meeting. It was getting a little confusing as to what needed to be done and who was doing what. And we also talked about things that possibly were maybe future chapters that the authors could add on later. So that's the nice thing about having a book like this, is that we can add future chapters on topics as they come or arise, or things that were not covered. The amount of topics seemed daunting at first, but definitely the way it was organized and rolled out for authoring and reviewing, it seemed to keep things really manageable. We added comments as reviewers and suggestions using redlining in the Google Doc, which is how most of this was shared to us, hoping to, change or improve clarity, brevity, comprehensiveness. And I was able to add, for example, add some of the language that our general counsel prefers on various areas, and asked the authors to maybe take a look at this or review this or just ask general questions. And it really helped solidify and confirm my own licensing knowledge, and also add to it for areas that I'm not as strong in, which is like liability, warranty. Those I'm always a little bit shaky on. So it was really helpful. I'm going to pass this off to Samantha, I think is next.
So to give you an idea of some of the topics we talk about in the book and how those work and the language we provide, I thought I'd talk about one of the major licensing endeavors that we've been working on at Berkeley, which is also in the book for you to review. So we have been trying to increase the accessibility of our e-resources as part of our university's equity and inclusion goals, as well as to meet new Title II requirements. So since the new ADA Title II ruling requiring that public institutions provide electronic resources according to WCAG 2.1 level AA, this has become a matter of ensuring we are compliant with federal regulations, but we've also been advocating for stronger accessibility language in our licenses for a couple years now, just in an effort to hopefully push the publishing world towards born accessible materials. So for example, typically most libraries will ask for a VPAT during licensing to determine the resource's level of compliance. And then if necessary, the library or disability office will make modifications based on the needs of its users. At Berkeley, we've been going a step further by placing the onus on vendors and publishers to make sure that their resources are accessible when we receive them, which eliminates the work of having to make reasonable modifications after the fact. It also helps us to avoid liability on the campus's end, as we've established that it's the vendor's responsibility to provide us with accessible materials, and that we're not purchasing non-accessible materials if we can help it. So to place the onus on vendors, we've started using new language in our contracts that asks for a warranty or representation that the vendor is compliant with California state and federal accessibility laws, as well as the web content and access guidelines, and a representation that the vendor will make reasonable efforts to solve any accessibility issues that do happen to arise. We can go to the next slide. So then we go down to the warranty disclaimer section of the contract, where you'll typically find language that says something along the lines of vendor disclaims all warranties and provides the licensed materials as is. So we've started adding language that prohibits the vendor from disclaiming the accessibility warranty they just provided us by adding "except with respect to express warranties" in front of those statements. So the vendor can disclaim all non-express warranties, but we've just asked them to give an express warranty that their materials are accessible. So we want to make sure that that statement is not in vain. And then lastly, We apply the same statement. Can you flip the slide, please? Thank you. We apply the same statement in the indemnification section. So the contract will usually say vendor shall not be held liable for any damages, which we amend to be except with respect to any express warranties. Vendor shall not be held liable for any damages. By adding this, if the university gets sued based on accessibility claims, then there are already contractual terms established that would have the vendor indemnify us and would shift that legal responsibility onto the vendor. This also helps the university with potential PR issues that would arise from an accessibility lawsuit, as we can point to our efforts to work with vendors that have specifically promised to provide accessible materials when we entered the agreement. We have found that the vast majority of vendors have been very accepting of new contract language with very little negotiation involved. Occasionally, smaller vendors won't accept certain parts of the accessibility warranty, like agreeing to California state law if they're in a different state, but we'll narrow down their concern and tweak the language to ensure that we get an accessibility representation that's agreeable for both parties. And we're particularly hammering home on that WCAG now that the Title II regulations are in place. So it's been very encouraging to see such willingness from vendors to provide born accessible materials. And we've tried to share our language with as many colleagues in other institutions as possible. So we're hoping that this book will help spread the word more and influence the publishing industry. And I will turn it over to Erik to talk a little bit about best practices.
Great, thanks, Samantha. As you've heard, this book contains a lot of useful information, and I think just as many ways to apply it during negotiations. Hopefully, some of this won't be new to you, but I did want to highlight and sort of bring us at a high level on some of the best practices based on its structure, and maybe a little bit, and share a little bit about how others are using it and how I'm using it. So first, I'll always encourage all colleagues to keep a student mentality about learning and applying licensing concepts. And like we've heard in the chat that many people have had varying degrees of formal and informal training. Every new clause or contract, from my perspective, is a learning opportunity to take the time to understand what you're signing. And the more you look up and question, the more confident you'll become. I try to stay as organized as possible. I keep a list of preferred language that I use often, and I'll document my justifications and include why I accepted or rejected certain terms. I'll note common objections from vendors as well. So these records make it easier for me to adjust language quickly. I can stay consistent across documents and vendors and explain my position clearly. It will also help from preventing tough negotiations that I know are either pending or I'll have to start from piling up because I'll have good practices I know that I can rely on. So whether you're just starting out or you're very deep into the work, the more curious and organized you are, I feel like the stronger negotiation position you have. And on the right of this slide, I took a screenshot of how the book appears on the website, and it has plenty of plus and minuses to sort of expand and see where things are. And I'll go into a little bit more on how to use it in a second in the next slide. So learning to recognize common legal and licensing issues does take time, and that's exactly what I think this book really helps with. We modeled its structure after standard licensing templates. So if you've worked with licenses before, this layout should feel very familiar. It starts with authorized use and users, moves through obligations of both the licensor and the licensee, and then covers key areas like term and termination. And then we get to our favorite, identification, and then lots of boilerplate language that can often be mushed into like a miscellaneous or a general terms. Any one of those found in that section can be its own section. Often I find it's a good place to add things where I'm not sure where it may belong in the agreement above. And so it's sort of like a nice catch-all if you have specific language that you're required to include. One critical concept I try to remind others about in this type of environment is to watch out for language about precedents. I mean, we've done all of this work to negotiate preferred terms. So you want to make sure your agreement includes a clear statement that says that the terms you've just agreed to will prevail and override a vendor's generally posted terms. Those are often tucked away online. They're often referenced in order forms. And we try to do this after all of the work we've put in to protect the integrity of that negotiated language. And here's an example of the book's search functionality. When I was sharing this with our analysts and other people that we've worked on the book with, not everybody knew that you can search the book and do a word search. So there's a little bit of familiarity you'll get once you're on and in it, but you can use this function to quickly find any topic. I often find it interesting because it will also pull where those terms might exist elsewhere that are being treated. And so you sort of have a full serendipitous experience of trying to learn a little bit about things that you didn't anticipate and maybe take a little extra time to learn something new when you're looking for something. And next slide. So I do think it's really important that we keep sharing our experiences. Licensing, it's only going to keep evolving. Here are a few quotes from early users of the book. And I feel like it shows a range of the way it's being used. Some readers are focusing on specific topics for learning. Others are integrating it into workflows and reviewing internal documentation. Personally, on the top right, I started to add links to relevant chapters directly into the comments that I'm redlining with vendors. It's not always the best idea. It's sort of a long link, but I do find that it's been helpful to support justify the proposed changes, give some opportunity for vendors to learn on their own, and maybe take the time elsewhere outside of this particular document, and just an overall good example of how the book can flex to meet different needs. And I think we have next steps.
Yeah, so I'm going to cover next steps. We would like to add more to this book. I don't know if in the future it will be the same authors, if we'll have new authors contribute. It was a lot of work, so I don't know. But our goal and our idea for it is to keep it going and to continuously update it so it is a living resource for licensing librarians. So we hope to add appendices about things like how to redline a document, how to do negotiations, and more of that foundational type of stuff rather than the legal heavy information. We hope to add exercises so you can practice redlining. And we hope to keep updating it with different AI clauses as they come out and we discuss them, Title II regulations, things like that, so that it is current and it is a useful resource for people going forward. If there's anything you'd like to see, you're welcome to email us and we'll take that into consideration. We love getting feedback about it. And then if we can go to the next slide. We just have a list of resources that you may be interested in. So as mentioned before, there's the ebook link, which is free, available on the internet for you to peruse. There's the Amazon print on demand link if you'd like to purchase a physical copy. And then there are just a couple links of articles that we've written, some with Catherine Klosek, the Director of Policy at ARL. And yeah. That is our presentation. So we'd like to open the floor to any questions that you may have. So you can put them in the Q&A or the chat, and we're happy to take questions. I do think there's a question in the Q&A right now, so I'll just pose it to the group. Does a licensing librarian take part in buying data on behalf of faculty, or is the role more defined? I think it depends on the individual campus and their data buying policies. I know at Berkeley, we do buy data for the entire university, and including faculty and students. We don't tend to buy data specifically for faculty unless it's something really special. And then our data librarian is usually involved in addition to our licensing librarian. But I don't know if that differs for anyone else on the panel.
We have had a handful of faculty that have requested data. We do tend to get it for the entire library, but there are also, or the entire campus. But I will say, usually it's only those faculty that have requested it that end up using it, like 99% of the time. So but yeah, we don't do it for faculty without offering it to the rest of the campus.
I'll go and agree with both of my colleagues. I do think, though, if you have the opportunity to join a call, there are things that might not come up organically when we start talking about data. And maybe this is focused specifically on where we're going to store it, how we're going to use it, whether or not it is low, moderate, or high risk kind of data. And so a lot of that stuff is something a licensing person would end up treating in the agreement that would be great to sort of push forward up into the initial evaluation. So whether or not you have space for it, whether it's in the right format, we're trying to push and integrate some of these licensing issues before they become problems after we decide to buy it. So it's becoming a little bit more of a robust process for us.
We have another question in the chat. Our university's policy is that we must strike all indemnity clauses that apply to us before we sign any license. We found it challenging to negotiate for language surrounding their indemnity regarding accountability for meeting accessibility regulations. Do you have any advice for navigating this kind of situation?
I can say that from our perspective, we've had a lot of conversations with legal about, what we have to require, especially with the Title II regulations coming up, and what we need our vendors to agree to. If we cannot reach an agreement, a lot of times what we'll do is we'll set up a meeting between our legal department and their legal department, because there's a lot more force sometimes coming from the legal department of a university than there is from one licensing librarian. And it also gives them the opportunity to kind of see where concerns are, what the concerns are, and where they can find common ground. And it's a lot easier to have in a phone call than back and forth over a red line document.
I would agree with that. We also tend to hammer home that it's part of our university policy that we can't move forward without certain things in the contract, certain accessibility standards. We link them to Title II information, and we kind of hammer home that we may not be able to move forward with this resource if we don't get kind of the terms that we need in this, or we're going to have to take it to our general counsel. That may take months. They still may not agree to move forward with it. So we do like to link them to anything kind of official from campus that backs up our claims that this is what we need.
And I will say, sometimes you just have to walk away from a resource. It stinks, but there's no way around it.
Yeah, and I would kind of just to add, have kind of like all your different levels that you're going to approach things. Like one is to just take a weed whacker approach to a license, and you see indemnification and you strike it, right? But as we all know, licenses are kind of living, breathing documents that have a lot of nuance and context throughout that impact, one clause can impact another one unbeknownst to you if you're not really cognizant of what the agreement is saying. So I think having a good relationship with your general counsel, knowing that there are different ways to approach the language that you and your legal counsel are agreeable to, and kind of having those steps in place, and then having that meeting being kind of the last resort. But I think, especially that relationship with general counsel is so important to get quick and fast turnaround time. We do so much work for our institutions by redlining these agreements. I mean, we are acting kind of and in a way that helps relieve their workload. And so our general counsel knows that. They do not want to see every single one of our licenses. And so kind of the give and take is that, well, you can give me 15 minutes, whenever I need it kind of thing. Because otherwise I'm just going to give you all my licenses, and they do not want to do that. So.
And I'll say a mistake that I've made in the past, and that from now on, like if I love my position, I'm not going anywhere, but if I ever were to go to another position, one of the first things I would do that first week is set up a meeting with general counsel. We kind of had an intermediary, like for a long time in the library, but having that direct relationship and having a good relationship makes a massive difference.
I call it training in a general counsel. Because I've had 5, and then I tell them eventually, like, oh, you don't know, but I was training you in.
The other day I was meeting with her and she was trying to come up with a word, and I was like, it's like this, and she's like, how do you know the legal terms better than I do? Something. And I was like, because this is the one that I look at all day every day.
There's another question in the Q&A. Have you experienced procurement staff seeming like they love to redline just for the sake of it? The libraries have generally approached most purchases and accompanying licenses as low risk.
This hasn't been my experience, but we are a pretty strict we have a pretty strong redlining practice at UK. Like, we get most of it up front.
Yeah, we're pretty heavy-handed as well on the redlining, so, and don't have to go through procurement office.
We also don't go through
Yeah, I'd also say from a personal perspective, if I'm already going into a document to try to add some preferred language, it's really hard not to try to correct errors or make parties' names consistent, flip-flopping from like library to subscriber. Um, or institution. I'll try to make it better, try to leave it better than when I found it. But it all depends on the appetite for your vendor. If they will sort of, sometimes that tone can come across as aggressive or sort of out of scope. But you'll usually be able to sense that. Yeah, it's just a style sometimes.
Right, it's a sense, like that sense is interesting, because I have 2 staff who do pre-redlining, and sometimes when they send it to me for the final like look through to send off, I'll say like, ooh, I know this vendor, I know how they feel about redlining. I will maybe, take out some of the things that I feel like their language says essentially the same thing. And I just want to get the red amount down. I think also, just from a practical perspective, to go back to the question, which is perhaps talking to procurement about what is low risk. I know that we generally consider library licenses as low risk. I think that that might not necessarily be true depending on the resource. So for us, we have a dollar amount that makes something very, very, very low risk, under $2,500. And we do have some leeway to do click-throughs, a non-negotiable license, with sending it to general counsel and saying, we'd like to use this protocol, which means we're not going to be able to change anything. And they say, this is okay. You are aware that these things are in the license, but these are acceptable under normal business practices, which has given us a lot of, like that $50 resource that takes you 100 hours to negotiate. Like, we don't have to worry about those. And that was a negotiation with general counsel. So perhaps coming up with some, like, your $3 million agreement is probably a little bit different than your $50 agreement in terms of liability for the institution.
I would say we view our licenses as a little more high risk than maybe others, but the campus has been sued over accessibility claims before. So I think we are a little nervous when we go into agreements. So we do tend to have a heavy hand with redlining. We've also been presented with a lot of data agreements in particular and business agreements where they're asking us to take liability for each individual authorized user, which would honestly take the campus out if we got sued because they decided to download too much or do certain things. So sometimes those things are important to look at, and they can be high risk if you don't redline well enough, because you don't want to accidentally end up in a situation where you are responsible for all of your authorized users. That gets pretty expensive pretty quick.
So there's a question on the chat. How long does it take to complete a new license from start to finish, typically?
I would say that varies a lot based on the type of license it is, the vendor you're working with. There are the things you control that are in your purview, how fast you redline, how fast your invoicing and acquisitions team works. And then there are the things you can't control, which is, does the vendor get back to you in a timely manner? Is it a difficult negotiation? And that kind of stuff. So we tend to tell our selector librarians that it's about 6 weeks, but it varies. It can be 2 days, it can be 3 months.
I've had licenses that I've turned around in like 3 days. I've had licenses that have sat on my desk for 2 years while we've tried to make it work.
Wow.
Yeah, we have a tracker that tracks business days from receipt of the original license to when, and I mean, it's Excel formula at business days. So the average for us, considering all the things that Samantha said, and all of the, our own like workflows and vacations and things like that, it's about 25 business days, which aligns with that 6 week. But yeah, I've had 2 years of, now amendments for us, which we try to push for, as long as, for our records, we do anything, we would renew a license, an overarching license, a minimum every 10 years. So amendments take us about 1 to 2 days.
So have you ever encountered a case where when you need to renegotiate, you end up canceling?
We have. That happens if we can't reach terms that we can actually agree on. So sometimes we'll update a license from 2000 or something, and things have changed so drastically, or the vendor's been bought out by a different company. They have different terms, they have different lawyers, and we can't reach consensus. And then we do end up canceling. It's rare. We try to do everything to avoid cancellation, but it does happen.
How do you communicate that to the faculty, students, other libraries?
Yeah, so I will say that as a licensing librarian, I don't communicate that as much at Berkeley, and that may differ for others on the panel. Our selector librarians, or like subject specialty librarians, are the ones who communicate that to their faculty and students within their department, in addition to our associate university librarian, who will help put out the word. But I don't know if anyone else has a different perspective on that.
We recently canceled something that had, I gave a presentation at ERNL on export controls and just an unwillingness to negotiate. And it really was, explaining it to liaisons, and they would, they knew who their biggest, the faculty who use the resource the most, the classes that might have used it the most. And then they talked to them, explained the situation, and they're pretty understanding in light of, like, I mean, sure, they don't understand like why it might be a problem per se, but they understand that the vendor is being, ridiculous. I think the hardest part is when this all happens in the middle of a semester and an assignment is being used for, or a resource is being used for an assignment. That's like my worst case nightmare scenario, because that's really hard to pivot for an instructor.
I think for me, while it doesn't happen very often, when it does, we're able to point to very specific reasons. And I feel like that's where, in my role, I can provide clarity and transparency around terms that are unfavorable, that don't align with the policies of the library or the university, any specific conduct or surprise negotiating or lack of negotiating. Um, all of those experiences uh, are used to evaluate um, whether or not something is worth the risk, right? So at least in my role, I'm providing information and sort of a risk profile, but I'm not making the decision. And so I feel like it's a much larger acquisitions or collections development role. If something is of a low value or a low use, um, these are typically, 12-month subscriptions. Um, and by the time you're getting it done, you might be overextending it into the subscription year, and then, about a month before you have to decide if you're going to renew. So there is a small window that you can potentially take on a little bit of risk to see long term how it would play out.
And we have, one of the things we're seeing, we've got already kind of got a couple of databases we're keeping an eye out because we don't think they're going to be able to meet the Title II regulations. And so we have talked to our liaisons proactively and just said, you need to be talking to your faculty about this, and they need to go ahead and realize there may be resources that we cannot renew because they expose us to too much risk. So if you know that something could be coming down the pike, just kind of giving them a heads up sometimes makes it a little bit less of a, oh no, we're in the middle of the semester and we can't, this course text no longer works.
Anyone else has a question? While waiting, if anyone wanted to, it's in the recent of a current decisions from the somewhere in Washington. What if using Title II is no longer permitted to be part of negotiation? I'm just like asking this out of fear, because I don't know the answer. I'm not a licensing librarian, but I do support access to faculty and students, but then also dealing with accessibilities. So if accessibility is no longer part of clause that we are permitted to use, I'm just rambling here, thinking out loud. So hopefully we have some discussion how we're going to approach this, because it will eliminate part of our users.
I mean, I don't think I've heard of any rumors or changes to
Knock
any.
on the wood, I won't jinx that. I don't want that happen, but yeah, we never know.
Yeah.
We have another question then. Have you found that a non-US based publisher put up more resistance against accessibility clauses based on US requirements? And do you deal with this vendor any differently?
Yes, we have found that non-US publishers do not want to comply with the accessibility requirements, especially the Title II ones, since they are US centric. Again, we kind of communicate that WCAG is a universal standard. So while it's part of our federal regulations to comply with it, WCAG is universal. So they are probably providing a similar level of accessibility for their non-US based clients, and they can, create a VPAT using WCAG. It's not just an American centric measurement. So we try to communicate that. We've also run into a lot of European publishers who are in the midst of their own accessibility regulations changing within their own countries. So we have tried to give a little grace and leeway with their compliance deadlines as well. Even US publishers, we understand that they have until 2026 to also meet compliance. So we're willing to push certain things till next year if we can. And same thing with European publishers, but really hammering home that it is a universal standard and they are able to meet it and they're not doing anything exceptional.
As one last questions, do you think there will ever be a central repository of accessibility data by vendor like VPAT, WCAG, fashion?
I don't think it's going to cover everything, but I'm going to go ahead and make a plug for the Library Accessibility Alliance. Has a really good repository of VPATs, vendor responses, WCAG standards for a variety of vendors.
Yeah,
I
that's a
would love
good
to see more
resource.
in there, but they tend to be sponsored by and paid for by the Library Accessibility Alliance. So there is, limitations on what they can afford to.
You can
add.
become a member of the Library Accessibility Alliance, and that will help support the efforts, and all of their reports are freely available and posted. Of course, they're out of date as soon, a few months after, but at least we know that some of, at a certain time, a database looked like this or looked like this.
Yeah, good point about that. Well, we are out of time. Thank you so much for the panels. This is excellent, and I learned a lot from your presentation, and I'm looking forward to read your book. Our next session is going to be, there will be a break, I believe. Yes, and then we'll meet again at 3:45 square.
Thank you for having us.
Thank you all.
Thank
Take
you.
care.